Welcome everyone. Hi, I can see some people entering now. Welcome to the Cappello Rowe webinar on debt during COVID. Welcome today. Thanks for joining in. I'm just going to give it a minute to allow everyone to come in. It takes about a minute or so before everyone can see me and see our screen. You should be seeing a presentation slide that says debt during COVID-19. If not, just jump onto the chat and send me a quick note, and I can see if I can try and resolve these technical difficulties. Otherwise, you're joining us today for our live webinar. It is being recorded, and you can ask questions through the Q&A function, which should be at the bottom of your screen. So the objective today is to talk about debt and then active steps you could take in order to prevent any bad debts during COVID. And the objective was also to provide information that you can use to make some decisions regarding your business, so really practical recommendations that we want to put through. So moving to the next slide, the people who are joining us today, we've got some great panelists. Firstly, for me, I'm Sarah Cappello. I'm one of the partners here at Cappello Rowe, and I run our litigation team. I've also got Joey Tash joining me here from Sydney. Joey's one of our lawyers in our Sydney office. Hi, Joey.
Hey, guys.
And we've got Laura Andriazza from our Griffith office. She's a lawyer who works in our litigation team as well. Hi, Laura.
Hi, guys.
We've got a very special guest today as well. We've got Daniel Swar from Jones Partners. He's a principal there, and he's going to be giving us some perspective from a liquidator. Hi, Daniel.
Hi, everyone.
Thanks for joining us today, Daniel. We really love to have your contribution. So just broadly speaking, we'll be approaching this topic in two parts. The first is to take more of a proactive approach and give some recommendations about what businesses can do in order to prevent the debt from becoming a bad debt. That's the approach that I'll be looking at. Secondly, we'll be looking at more of the reactive steps that you can take, and Joey and Laura will be setting out what you can do once the debt becomes a bad debt. Then Daniel is going to be exploring the insolvency aspect, so what happens when one of the parties becomes insolvent and what this means. And this is really to give some insight about what you want to try and avoid. Then I'll be giving an overview of all of that and some key takeaway points. But first, I wanted to share some very exciting news. Most people who are joining today already know about the news that of our upcoming merger, but we're very excited about this. We'll be joining the team at Hunt & Hunt Lawyers from 1 October. So there's a nice little picture there of Jim Harrowell, who's the managing partner there, and I, where we were happily chatting about the prospects moving forward. But Hunt & Hunt are a fantastic firm. They've got a national presence, but specifically we'll be joining the office in New South Wales, where they've got a Sydney office in Bly Street. And they also have an office in North Ryde. And then we will obviously be adding our Riverina office, our Griffith office as well to the firm. But we're really excited. There's a lot of synergies between the two firms, and ultimately it just we believe it makes our firm a better firm because it'll allow a lot greater access of us to resources which we otherwise don't have at our disposal. So it'll really be the same people you're dealing with, the same clients, the same matters, the same great service that we currently provide, but just on a different scale with more resources. So we're really excited because we believe it's going to just take us to a whole nother level. But any questions about that, just shoot them through. Otherwise, you should be getting a lot of information about how excited we are about this soon. Now, getting into the topic of today, debt during COVID. So firstly, I wanted to mention, and this is the approach I often take, is that I encourage businesses to take a very pragmatic approach when handling disputes, and with respect to debt and anything broadly. It's really important to take commercial approaches with these things because ultimately you're running a business. The objective is to make money. Now, what we believe is occurring, and this is my opinion specifically, is that businesses are artificially being propped up at the moment because of the government support that's being flowed, which is great. It's a great response to COVID. However, my concern is that it's going to then create a bit of an artificial sense of relief where, and this is the feedback I get from clients, where businesses are paying their debts, they are doing things, they're keeping afloat, they're paying their employees. However, it's likely that, particularly given the extensions to the relief regarding insolvency and bankruptcy, that there's going to be a huge avalanche of winding up and businesses who are impacted from this. And in that event, we're encouraging clients now to take proactive steps in order to avoid them becoming one of those businesses, or becoming involved with one of those businesses where they can't recover debts and leaving them significantly exposed. So the messaging I want to give here is to say, even if you think that your clients are paying debts even when they fall due, there could be ramifications from this. So one of them is, and we were discussing this just a little bit earlier, is, acting quickly is really important. And one thing that people often don't realize is there is a period of 6 months where even if payments are made, it could be deemed to be a preferential payment, in which case it has to be paid back if certain criteria are met. And I won't get into those details, but getting paid sooner rather than later, so that the furthest away from an insolvency event, is very important. So it has quite a big impact to a lot of businesses. So there is terms floating around right now, which you might have heard of businesses being called zombie companies. So these are companies that are otherwise being propped up with government support, but otherwise would be insolvent. And we're seeing this in the stats relating to companies who have been placed into liquidation, where there's a decline in the order of about 38% in liquidations from this same period last year. So it's creating, as I said, this artificial sense of businesses continuing that otherwise shouldn't be in operation. So we think it has kind of wide-ranging impacts, and Joe's can just talk very briefly about the cascading effect that can flow from this.
Yep. So basically, what we're finding is, most businesses are being impacted, even if they're not directly impacted by COVID. Given today's society, most businesses are interrelated, which is obviously creating a ripple effect, impacting other businesses. One example is the wedding industry, where many couples nowadays are in limbo, given the restrictions on weddings. They're postponing their weddings in the current circumstances. Now, the venues obviously miss out with the postponement, but at the same time, it means that hundreds of their suppliers are now in limbo as well as being impacted. Another perfect example is the construction industry, where, and this is the reason why the government is trying to propel it as much as it can, because, if you push the construction industry to, for buildings to keep going, there's hundreds and hundreds of trades that are indirectly impacted by the construction industry. So, it's just another example of circumstances where it's the COVID is creating a ripple effect on many businesses, whether they're directly or indirectly impacted.
Yeah, and we definitely don't want to give the messaging of that's doom and gloom. Really, what we want you to take away from this is be proactive, and that goes into my next slide. So we want to really encourage you to take steps and understand what those steps are in order to avoid getting involved in this cascade or avalanche of liquidations, which we are concerned will arise. We want to make sure that our clients and our networks are protected from this. And there's some selfish reasons and other reasons involved in this too. We want our communities to maintain, growth, and we want businesses to be okay. Now, in this note, with being proactive, there's a lot of things that you can do in order to prevent actions being taken, and you need to set these up early before you're dealing with customers, or if you are dealing with customers now, then rectify these issues as soon as possible. The first and most obvious one is to have clear terms and conditions, and also credit applications or agreements. Now, when you're dealing with customers, and there's a bit of a focus here on predominantly professional services, but it does extend to a lot of different industries. So, if you wanted to raise any of these questions in the specific context regarding industries, then please do so. But if it is very specific, we'll take it offline later and have these discussions. But in most businesses, where you're dealing with a client who is effectively going onto credit terms, and this means you're providing a good or a service and they're paying for it later, you have to have clear terms and conditions. Now, it's important to do it for a number of reasons. The first being, you want to make sure that the terms between the parties are properly understood so that you can rely upon it later if you need to. And secondly, you might want to rely upon these terms and conditions in order to actually seek some security. And this is what I'll talk about later. So the first is making sure that you have a very well drafted terms and conditions and credit applications, and that they're properly used and implemented with clients. The second one is the due diligence. Know who you're dealing with. Firstly, and it's surprising how common this is, know who your client is or your customer is. It's often the case that people don't understand whether they're dealing with an individual or a company, or is it a company that's called the business name, or is it just a business name? So have some information, understand who precisely the client is. If it's a company, perform an ASIC search. Find out whether there's any winding up applications on foot. Find out if they have a bad credit rating. If you can't do this for a number of reasons, then get some references, get some trade references, call the accountant, just do some basic due diligence. Obviously, again, as I said earlier, there has to be some practical considerations for this. If you're dealing with a client who's got $100 credit, you might not want to go to this extent. But if you're dealing with a client who you're exposing yourself to thousands or tens of thousands worth of exposure of debt, then these are very small things that you can do, which will allow you to then get paid later. The third is having a debtor policy. Now, I'm a really big fan and advocate of debtor policies for a number of reasons. Firstly, it tells everyone precisely what you're meant to do and when, and who is doing it, which is important, and it's not them getting overlooked. And secondly, that allows you to have something to talk to your clients to say, to kind of fall back on, because asking for money is a little bit awkward. I understand, and this is how I feel often the case. You don't really want to be asking your clients, hey, can you pay my bill? You just want them to pay it. But having a debtor policy to refer back to then allows you that extra, discussion to say, listen, our debtor policy is, if you haven't paid by the due date, this is the next step, and this is the next step we're getting to. So also with respect to policies, having a really clear process of what happens when somebody wants to dispute a bill, because it is the case often clients, sometimes the reason for not paying is not merely because they don't have the money. It could be because they're not happy with the service, or they could otherwise be querying the amount. So have a process to handle that. And by finding out that information sooner rather than later, it allows you to deal with it. Now, and the last one, which is, again, it's quite amazing how often this comes across, is to have a clear due date, either on the invoice or the statement, or whatever mechanism that you're using in order to seek payment. Make sure it's clearly identified when it's due. Often we'll have somebody come to us and say, listen, I've got this outstanding debt. It was due on the 1st of January. And I say, well, where does it say that on the invoice? And it has no defined date. So that's a really simple approach that is often overlooked. And mostly on that point too, is make sure that it's enforced. On the 1st of January when it's due, call up, or even in advance, say, friendly reminder, your invoice is due on this date. And it's quite surprising that how effective these methods are. It's really simple and often tasks that admin support can provide in order to secure payment. But ultimately, the best practice, which is what we'll be speaking about next, is to seek security. So this is actually steps that you can take, particularly if you have a large exposure, in order to ensure that you have some fallback provision if you can't get the debt paid. So what I mean by this, if your client is a company and you're dealing with a $2 company that otherwise has no assets and otherwise is trading a business but otherwise is not worth anything, if the company then is wound up, then you have very limited recourse if you don't have security to seek payment. You effectively, and I won't encroach upon Daniel's talk, but essentially you have limited recourse unless you have security. So one very, very common thing is to get a personal guarantee from the director or the directors of the company. Now, it really is a commercial consideration as to whether the director will agree to this or not, but it's something that you can require as part of your trading terms. The thing is also, if you're dealing with a company who is a subsidiary of a company, you might want to get a guarantee from the parent company. Another one that I would advocate for strongly, given the cost benefit analysis, is to register on the PPSR. Now, I'm not going to go into a lot of detail about this. I've done a couple of seminars on this previously, and we have a lot of resources on our website talking about PPSR, but it's a fantastic option that's available to businesses that is really inexpensive and secures goods. And this is particularly the case when you're selling items on credit. And it has such a wide application. However, it even extends beyond to service industries. Now, it is a little bit of it can be perceived as complicated. But at the same time, it is complicated and it isn't complicated, but at the same time, my view is that you always should assume that you have the potential to register an interest. You just have to properly articulate it and then explore reasons why you wouldn't. So look at that as a first course. What can I do? How can I secure my debt or my exposure on the PPSR? Another option would be to look specifically at your industry. So can you exercise a lien? Or if you're in the construction industry, Security of Payments Act. An example of this is in my own industry. So lawyers, for example, have a recourse that they can pursue with respect to invoices, where clients and lawyers have a right to have those fees assessed. So that's a very specific response that you can rely upon in the industry. And there are a whole heap of examples of these in other industries. So go to your industry body, find out what recourses do I have, what resources do they have available to me in order to make sure that I have some kind of security or assistance in getting paid. Now, I put there number 5, and this isn't security, but it's actually a good practice that I've found applies to a lot of businesses, is to get some direct debit authorization or credit card authorization. Now, there's some steps you got to go through, which I won't outline, but it is a really good recourse as a backup and making sure that you go through the right channels with that. But it's a way to essentially assist in getting paid. Now, if you haven't been proactive and sought to take these steps initially, then it can essentially lead to a lot of financial stress and insolvency. And this chart is a chart that's essentially pre-COVID stats relating to the recovery of debt within certain time periods. And it is pretty common ground that the longer you leave a debt, the harder it is for it to recover. So this is where an example of the emphasis that we're placing on take steps quicker rather than later. Now, obviously the recoverability diminishes over time, and we think it's going to worsen with COVID, but the messaging we want to give is really very clearly have a plan. Be proactive. If you can't be proactive, then act quickly. And so I'm going to hand over now to Joey and Laura, who will talk about what you can do once a debt does become a bad debt.
Yes, so if you're in the position where you've given a few reminders and you've been chasing your debt for a few months, this is unfortunately where us lawyers generally come into play. And the first thing we generally do once a client comes to us trying to chase a debtor is to send a letter of demand. Now you need to do that before you commence proceedings anyway, but it can be a good last chance for the debtor to sort of pay the bill or discuss what the issues were with the account, etc. Sometimes sending a letter of demand, giving them 7, 14, 21, something like that days notice, saying, look, if you don't pay your debt within this time period, we're going to commence proceedings, or in some instances even attaching a draft statement of claim to show that you are serious about progressing. That can sometimes be enough to encourage the debtor to just make the payment, because essentially once you get to the point where you're commencing proceedings, you're incurring further filing fees and interest, which if you were successful in those proceedings, the debtor would actually have to pay. So it can encourage them to take action at that point, or at the very least, they may seek legal advice at that point, which their lawyer may then encourage them to negotiate, which I guess brings us on to the next point. Look, you can negotiate at any point really, and we always advocate for this to occur as early as possible. Excellent if it can occur even before a letter of demand is issued. If you have a particularly good customer who's a recurring customer and you want to preserve that relationship with them, you might enter into a sort of a payment plan or something like that to try and sort out the issue between you before things have to progress. But unfortunately, most often it is the case that you'll only end up negotiating once a statement of claim is filed, and that's where the deed of settlement sort of comes into play. If proceedings are on foot, you may not always need them. For example, if you negotiate a settlement where they're going to just pay the whole amount, they've agreed to pay the whole amount, the deed of settlement may not be necessary. You may just discontinue the proceedings and everyone walks away. But if you're agreeing to pay part of it, for example, then there may be a deed of settlement, which basically will bar the parties from progressing any further with the claim that's brought. But if you do have to commence proceedings, it's usually, look, in the time of COVID, where we'd encourage this to be the best course of action, and Joey will touch on this further, but it's basically because of all the extensions that have been provided to bankruptcy and insolvency and things like that. But generally speaking, it's the last course of action, because it will most likely have the effect of diminishing the relationship with your customer. So I guess commencing proceedings is relevant where you really can't get onto them at all. They're just not responding, or there is a dispute as to the amount owed or something like that. You always need to weigh up the commercial factors though. For example, for claims under sort of $20,000, they'll be run in the small claims division of the local court, where legal fees are capped. So where generally the winner of proceedings could claim their costs, in local court small claims, it's limited, and it's most likely that you won't recover a significant portion of those costs. It's
about a few thousand when it's in the small claim. So unfortunately, it's the reality of the situation with small claims. If you know, the preparation, all that is required. But unfortunately, given the small quantum, you know, doesn't matter if you've incurred $10,000-15,000 worth of legal fees, you're only going to get a small percentage of it, unfortunately, in small claims.
Just as a counterpoint to that, Laura gave us the example yesterday of a client who had been served with a statement of claim for a relatively small amount, but it prompted the person to pay it. So
yeah,
sometimes it can have that effect of getting a quick payment when otherwise no recourse is available. But again, as Laura said, weigh off the commercial realities.
Yeah. So yeah, no, that's true. We, you know, if it's sort of within $1,000 to $2,000, sometimes people come to you and they just say, you know, what do we have to do to make this go away? They don't want to defend it because simply defending $1,000 claim, you know, it's going to cost more to file the defense anyway.
Yes.
So it can have, you've really got to weigh up the commercial factors.
yeah.
But that brings us on to point 4, statutory demands. So Joey will talk about this in more detail, but essentially they're not an enforcement method, but they do often encourage the debtor to make payment, because essentially if they don't, they can lead to winding up proceedings, and most entities obviously don't want to get to that point. It's only relevant for entities when you're dealing with a debtor who's a company, and like I said, Joey will discuss that in more detail, but it can otherwise be, it can only be used, where there is no dispute. So for example, if you have an invoice that's due to be paid, if it's just the case that they haven't paid for whatever reason, you could go down the path of a statutory demand. But if you expect that there is going to be a dispute in relation to the amount, whether it's a dispute in relation to the services or goods supplied, etc., it's not going to be an appropriate mechanism, because that's not what its intention is for. But I'll let Joey speak more on this point.
Okay. So yeah, as Laura was saying, you know, another mechanism in the debt recovery process is either the commencement of bankruptcy proceedings against individuals or winding up proceedings against companies. Now, I'll talk about the temporary changes implemented in a moment, but just wanted, for anyone who may not be completely aware, briefly explain what statutory demands and bankruptcy notices are. Now, as Laura was saying, a statutory demand is basically a formal written demand served on a company by a creditor for payment of its debt within a specific time frame. The company must then respond by either A, quickest ways to pay the debt, or alternatively, if there is, they can make an application to set it aside, with the most common grounds being either if there is a genuine dispute to the debt, or the company has an offsetting claim, or the statutory demand is defective, because stat demands are, it's a form, but they're very strict on the form. So if there's any variation on that, then it can potentially be defective. Now, as Laura was saying, the case law is pretty clear on statutory demands, where it's not the right mechanism to recover debt, but it is a very useful mechanism to lead to an insolvency event. Now, for individuals, there's a thing called bankruptcy notices, which is again a formal demand for payment of money by a creditor issued to an individual for payment of a judgment debt, again within a specific time frame. The individual in these circumstances as well can either pay the debt or, again, make an application to set aside the bankruptcy notice on various grounds, either that the judgment debt is being appealed, so they can try and set aside on that basis, or again, if there's an offsetting claim that exceeds the amount of the judgment debt, or there are also other relevant grounds at the court's discretion. Now, in respect of bankruptcy notices, again, failure to respond, either pay or seek to have it set aside within the time frame is considered an act of bankruptcy, which then gives the creditor grounds to apply to the court to have the debtor made bankrupt. Now, pre-COVID, the process for statutory demands and bankruptcy notices were quicker and less restrictive. However, in March 2020, the government announced temporary changes to insolvency laws in light of COVID-19, which were initially due to expire on the 25th of September this year. Now, the purpose of these changes were to provide temporary relief for financially distressed individuals and businesses by effectively avoiding unnecessary bankruptcies and insolvencies during these trying times, to provide businesses with a safety net to enable them to continue to operate during a temporary illiquid period, as opposed to entering into voluntary administration or liquidation. And as well as individuals with a safety net to manage its debt and avoid bankruptcy. Now, on the 7th of September, the federal government again extended its temporary insolvency and bankruptcy relief to enable businesses to continue to operate during this ongoing coronavirus crisis, where we are in unprecedented times, and the government is taking the appropriate measures as it sees fit to sort of help these businesses, individuals, I guess, get through to the other end. Now, the extension will remain until the 31st of December, and until such time, it will either end or the government may, we'll have to wait to see whether the government will do another extension. Now, just briefly, these temporary measures summarize are as follows. A stat demand, the minimum threshold for a statutory demand for a creditor to issue remains at $20,000. Now, I know previously it was $2,000. So there's an $18,000 jump there. And the debtor company has 6 months to respond to the statutory demand. It was previously 21 days. So there's a significant period of extension there. In relation to involuntary bankruptcies, the minimum threshold, again, remains at $20,000. It was previously $5,000. So there's a $15,000 jump there. And again, a person has 6 months to respond to a bankruptcy notice, which it was previously 21 days. Now, in relation to insolvent trading, directors will continue to be temporarily relieved of their personal liability for insolvent trading to debts incurred after 25 September until 31 December. But it's important to note that these debts need to be incurred in the ordinary course of the company's business. However, this protection obviously does not extend to cases where there's any dishonesty or fraud, which are still subject to criminal penalties. A director is essentially taken to incur debts in the ordinary course of business if it is necessary to facilitate the continuation of the business. As the Australian economy has plunged into its first recession in nearly 30 years, it's clear that the government's making these temporary reliefs to help financially distressed businesses and individuals to potentially avoid, as Sarah and everyone here is saying, an unprecedented wave of winding up and bankruptcies. Now, in saying this, however, the extension is likely to unavoidably cause delays in creditors seeking to recover their debts owing to them. And it's a catch-22 because this will then create a flow-on effect to those creditors that would owe debt to their creditors and so on. So, but I mean, there are a couple of benefits in the extension. I mean, one benefit is it does give directors additional time with the safe harbor provisions, additional time to get some advice and, if appropriate, implement certain safe harbor plans designed to achieve a better outcome for their company instead of the immediate appointment of a liquidator or voluntary administrator. Now, obviously, seek advice at that time to see what the appropriate measures can be implemented. Now, another thing is, although the extension of the temporary relief has prolonged the process from 21 days to 6 months, which is quite significant, it's still, the message is it's still beneficial to take action now rather than wait, because I guess the benefit is if you take action now and issue a statutory demand or a bankruptcy notice on the debtor, there is more of a chance where you can ultimately maybe reach an agreement with the debtor for repayment of the debt and potentially increase, your cash flow in the interim. For example, issuing this notice may prompt the debtor to know, okay, well, after, if you issue it now, after 6 months, they'll know they can potentially be wound up or made bankrupt. So it may prompt them to enter into a repayment plan between now and 6 months. And the other benefit here is, you increase your cash flow during this period. And at the end of the six months, say, you're owed 50 grand and, they've paid 40 grand, then you make the commercial decision whether you want to recover the additional 10 grand, which you can, or alternatively, not pursue it. But I mean, that's just, one benefit of acting now rather than waiting 6 months. But the thing is as well, although statutory demands and bankruptcy notices look like they're pretty straightforward documents, it is very easy to get them wrong and ultimately have them set aside by the court. So in those instances, it is best to get some advice prior to proceeding with them. Yeah, so that's in relation to the extensions and the bankruptcy relief.
Thanks, Joe.
Yeah.
Sorry to interrupt you there, but it's a good segue then to be introducing Daniel, who's our special guest for today, who is a liquidator. He's from Jones Partners, who are great referral partners of ours that we do a lot of great work with that specialise in personal and corporate insolvency. And so we've asked Daniel to come on today to give us a bit of insight into what happens when a liquidation event does occur and the approach that you take from either side of the coin. So I'll hand over to Daniel now.
Thanks, Sarah. I guess first of all, before we get into what could happen if one of your clients or one of your clients' clients go into some form of insolvency, and in this particular case, what we're going to talk about today is liquidation. Because I know that having a chat to Sarah throughout the course of the week, there's going to be a further presentation on restructuring and recapitalising a business and how that ultimately impacts you and how it impacts what return you might get back from that particular appointment. But before we get into what could happen in a liquidation scenario, I think it's important to, from my side of things, to understand and to communicate with your customer. We're in very uncertain times at the moment. We're in times where you might have a very, very viable business pre-COVID who has been significantly impacted during COVID and has potentially been a very, very long-term profitable customer to you. And one of the things, and we've heard the word proactive a lot this morning, and I can't support that strong enough in relation to recovering debt through COVID. Obviously, pre-COVID and post-COVID is going to be a completely different scenario, but during COVID now, where you've got a long-term client that you want to try and keep moving forward, being proactive is the most important thing, and to communicate with that customer now. And what I mean by that is, before COVID, when I was appointed liquidator to a number of companies, the director would quite often say, there's a whole bunch of debtors here for you to go and collect, liquidator. And I'd say, okay, that's great. Is there a dispute with them? Why are they not paid? And the director would say, you know, there might be one or two disputes with one or two of the debtors, but generally the customers haven't raised any disputes. I just haven't gone hard enough to collect them. And when I then pressed the director as to the extent of what their recovery effort is, it could simply be someone in their accounts team has sent an email. It might be a threatening email or a follow-up email to say, unless you get payment within 7 days, we might commence litigation. And that's the extent of it. So I come in as the liquidator and telephone a lot of those customers. Our teams telephone a lot of those customers or write very generic letters. And I'm quite often surprised at how many of those debtors are then collectible, either just by a phone call, from getting an understanding of what they're going through as the customer and their ability to pay. And I'm raising that now because of my comments earlier about COVID and some long-term customers that you might have had that actually are genuinely struggling. A telephone call might result in two things. It might result in a fair chunk of your money being paid. So you might have a phone call with a customer that's quite long-term. And I must stress that what I'm talking about now is generally in relation to the SME market. Obviously, a much larger corporation would probably take a different approach, but generally the SME market might want to consider reaching out directly to the customer and getting an understanding of the capacity to pay. And going to what Sarah, Laura and Joey were talking about before, you might be able to get a decent settlement out of them now and payment terms for the balance. And you might also then be able to keep a debtor a customer that you want to keep moving forward once we all get through what we're going through at the moment. That's communicating with the customer to me is important. And also in that line of communication, it might be that customer says to you, well, I can't pay the full amount, but I can pay a significant amount now. And I want to look at doing that via a deed of company arrangement or a voluntary administration process. And quite often directors struggle to come to terms with that they can offer creditors a compromised amount and creditors can accept that. So if you're speaking to your customer and they're talking about not being able to pay the amount in full, but to be able to pay a significant amount of that and they want to do it via a deed of company arrangement, then you might want to talk about to that customer whether you're prepared to support that or not. And if you are prepared to support that, there might be opportunity for you to keep working and keep a profitable relationship with that customer moving forward, particularly as we come out of COVID, and hopefully that's fairly soon. Just to the next slide there, Sarah. And again, this what I'm talking about now is directed to the SME market, and those people that are listening that are either have never had a touch point with an insolvency practitioner, or have had very limited experience with an insolvency practitioner. Obviously, if you're listening and you are a liquidator or you are a lawyer in this space, then you probably would have, you certainly will understand what I'm talking about over the next 4 points there. But this is generally directed for those that have limited or no experience in dealing with a liquidator. So these next points are where you've made every effort to try and recover your debt from your customer, but the customer then goes into liquidation. And first point, whilst it's not on the slide there, is the first point to note is that if you've commenced recovery proceedings before your customer goes into liquidation, those proceedings are stayed. So you can't continue on with those proceedings once the liquidator has been appointed, unless you make an application to court to continue on with those proceedings. And that very rarely happens, because ultimately you'd be seeking leave to proceed against the company to ultimately wind it up anyway. So it's already being wound up by a liquidator. So those proceedings do get stopped, and you can't proceed with them. But the first thing there is, will I be contacted? And that might sound like a very strange question, but yeah, the liquidator has an obligation to reach out to you very, very early on in the appointment. They have a set number of days under the Corporations Act to write to you as a creditor of that company that's in liquidation. And importantly, if you're not, or if you haven't been contacted by that liquidator and you're aware that your customer has gone into liquidation, then you should be reaching out to the liquidator as soon as you can. And I'll come to why that's important in a moment. But point number 2 there, the process, there's a whole bunch of stuff that liquidators do in the background that the creditor and others might not get to see, but there's a whole bunch of stuff there that's done in the background. But the 3 key things that you will get to see and you will get to be involved in is securing and realising the assets of the company. And we're talking today about recovering debt and recovering some money. And the liquidator's job is to get in there and find what assets there might be, what assets are available, whether that's stock, whether it's plant equipment, whether it's cash at bank, whether it's debtors, for example, and get those assets and realise them to the best of their ability to try and maximise what might be coming back to you as a creditor of that particular company. Second key thing there for the liquidator is to conduct an investigation in the affairs of the company. And this is where you can, whether it's you or your client that is now the creditor of this particular company in liquidation, this is where you can really become active and engage with the liquidator. The liquidator will hear one side of the story from the director and start to pull that story together from the company books and records and other information that's available to them from the records of the company. But importantly, and this is from my perspective as a liquidator, I also like to hear from the creditors as to what their view of what's happened and what could be available is important. And again, that's important because if that information that you provide to the liquidator helps the liquidator then recover significant monies, that once the company's in liquidation, that's potentially where you're going to get a return for monies that you're owed. And what I mean by that, I'll give you an example of what I mean by that is that a liquidation we've done recently where we were contacted by a whole bunch of creditors who had done a whole lot of work on the director's personal property, so his family home, a whole lot of renovation work and really expensive renovation work and high-end renovation work. And what the director had said to those particular parties was that don't invoice me directly, invoice the company. and the company ultimately made the payment for those works. So we come in as the liquidator and find out that, and that was through conversations that we'd had with the creditors of the company, where, you know, they tipped us off to say that, and I'm sure we would have found it in the books and records of the company at some point anyway, but it really helped us progress a claim that we had against then the family home for company monies that had been spent in renovating that family home, and really put us in a position where we could pay a significant return back to creditors. And that type of information that is available, creditors do have another side of the story, and one of the other sides is that if you're a supplier of stock and, you know, a week ago you've supplied $1 million worth of stock, liquidator comes in and says there's only, you know, $50,000 worth of stock. That's interesting for us to know, because we want to know what happened to the stock. Where is it? Has it been consumed? Has it been moved somewhere else? Has somebody else got it? Has a related party got it? And that then starts to bring together what we can then look at and recover to get more money for creditors and get a return back to people who are owed some of this money.
With that stock example though, Daniel, that our clients are going to have a PPSR against that, because they're going to listen to our advice and do it, so they'll be able to have the stock returned to them.
Yeah, but importantly, it's good to know if it's on a job site, if they're aware of where that stock could be. So it's one thing to turn up to a factory and see it empty, but within the industry, they may actually have some intel as to what or where the location of some of that stock could actually be. Next thing there is, please become involved in the process. And I encourage those that are listening that are accountants and have a client base in the SME market, and one of their clients goes into liquidation, one of their debtors go into liquidation, get involved with the liquidation process as best as you can. Next thing there at number 3 is, will I get paid? And if not, what does this mean for me? So if you don't have security, and I know the guys have spoken a lot of this morning about security. If you don't have security and there's no return back to you as a creditor because there's no assets available for the liquidator to realise and distribute, then you need to really have a serious look as to what your financial position then becomes. Are you now insolvent because what you thought was money due and payable to you is now not coming? Do you need to get advice from your lawyer, from your accountant, and even from an insolvency practitioner about what your financial position is now, given that you may actually not get a return once the liquidation has been completed? And the fourth thing there, and the guys have touched on security a fair bit this morning, so I won't go into too much detail about the security side of it, but a couple of things to think about when you're looking at security. One of the things we talked about earlier was personal guarantees. When you're looking at getting your personal guarantee, and ultimately when you're looking at enforcing your personal guarantee if a company goes into liquidation, have a look to see and make sure you get historical searches, property searches, because what we're seeing a fair bit at the moment is, whilst that particular individual, when they gave the guarantee to you, may have actually had residential property which you can then support the guarantee with, ultimately they've divested themselves of those assets. So that then becomes another course of action for a recovery. And what I mean by that is that if you try and enforce your guarantee and the director says, well, I've got no assets to pay, do your best, I don't know where you're going to get a recovery from. It's important to make sure that your advisor gets a historical search to see, did this particular individual divest themselves of assets, you know, within a certain period of time, which are then recoverable. Property might have been transferred to family members, to spouses for no consideration. So they're the types of things we should look at. And importantly, with getting a guarantee from a parent entity, that once a company goes into liquidation, it's important to also realise that it may not be as simple as having a guarantee against a parent entity and trying to enforce that, because when a company goes into liquidation, there's potentially an insolvent trading claim that is available for a liquidator, and a parent entity is ultimately liable for an insolvent trading claim as well. So that parent entity, which may have been solvent and have capacity to pay under a parent entity guarantee, because of a potential insolvent trading claim it now has against it, it may no longer have the capacity to meet any personal guarantee or any parent entity guarantee that it's provided as well. Final thing there in relation to PPSR, and Sarah's mentioned it quite a bit this morning, that's probably one of the most important ones, PPSR over your stock. Once a liquidator is appointed, they do have an obligation to contact you and ask you for details about your security. Make sure your paperwork's in order, and that's where the team at Cappello Rowe can really help you getting that paperwork in order. Make sure you're registering it over the right stock and the right company and the right ABN and the right ACN and all those types of things, and that's where those guys can point you in the right direction to doing that. But a couple of practical things: if you're a supplier, or if your client's a supplier and they have a valid PPSR, don't wait too long after liquidation's commenced. Get in there straight away. Ask the liquidator for a stock take. Compare that stock take to the stock that you say you've provided. If there's discrepancies, raise that with the liquidator. Ask if you can go and inspect the stock on the premises, see what's there. You might have supplied a whole stock on Tuesday morning, and by Wednesday the company's in liquidation and it's disappeared. There needs to be an explanation as to what's happened to that stock and where it could have gone. So you need to really engage, and that's a really good point that the team have made this morning about the PPSR and engaging quickly once a company goes into liquidation, because you don't want to miss the boat as to where some of this stock could be. And you also need to consider if your stock's perishable, and how quickly you can get in there and access that stock, because if that stock is perishable and has value, you don't want to be taking weeks and weeks to liaise with the liquidator about whether your claim's valid or not, whether it's supported. You want to get in there pretty quickly, and it might be that you can consent to the liquidator realising that stock on the basis that those proceeds get accounted to you. But if it's perishable, get in there very, very quickly. And the final thing I'll raise before I hand back to Sarah is that if you've got stock that you supplied and you've got a valid PPSR over that stock, and once a liquidator is appointed, if the stock's no longer there, so it might have been sold in the ordinary course, that's okay. Check with the liquidator and seek advice. You might have a claim, or you might then have security over the cash that's sitting in the bank account. So if your stock's being converted to cash and it's sitting there, notwithstanding that your stock's been sold, you may genuinely have security over that cash, and you might be able to get a recovery that way. And there's a whole lot to talk about on that, and a whole lot to think about and get legal advice on that. So that's just a general comment, but think about that. Don't just think because your stock's gone, you've missed the boat. And also have a think about if your stock has been sold, and there's now a debtor that needs to pay the company for that stock that it's got. You may actually have a security interest over that debtor now. And that's really important to think, okay, and we're talking about debt recovery here. What are some of the ways I can get some money out of this? And those are the types of tips that you should be looking at in relation to PPSR. And again, I'll go back to it. Engage with the liquidator early on, because you might have information that could result in a pretty good return back to you if you've got that information available.
That's some amazing points there, Daniel. And it kind of really goes back to our messaging of being proactive, because all of that recourse that you just mentioned there, specifically with respect to the PPSR, you have to have done before the insolvency event. You have to have watched the PPSR. So it's the messaging that you need to take away from today, which leads to the next slide, is be proactive, get everything in order, make sure that you have yourself set up so you don't have these exposures. So thank you, Daniel, for that really comprehensive advice. It's really interesting. I personally love the investigation aspect of cases. As you know, we've talked about this many times, but there's often a lot of avenues that you can explore, and you just need to get the right people involved in this. So there's our key takeaway points. So thank you, everyone, for joining in today. I hope that you've got some valuable information out of this. And if you have any questions, then please shoot them through to us either now or later on. You should have my contact details, and if not, I'll send you through a copy of this recording. But we definitely want to make ourselves available to all of our clients and our networks to answer any questions, to help you through this process. So we want to share information and our knowledge, and likewise, we would love for you to share your information and knowledge if you have some as well. And so, you know, we want to keep doing these webinars and giving as much information as we can and sharing our resources. And then, so I'll sign off here, but just as a quick plug in for our upcoming merger. We'll be sending through our new contact details soon, but we'll be otherwise just hopefully doing the exact same things we're doing now, sharing our knowledge, you know, reaching out to our networks and helping each other out. So get in touch and hopefully we can have a coffee soon. It looks like that you know, we'll be able to do that even this COVID environment. So we look forward to catching up with everyone soon. But thanks very much. Thank you, Daniel. Thank you, Laura. And thank you, Joey.